Hello and welcome to Sidebars. I am so excited today to have my dear friend and colleague, attorney Jenn Johnson, on the show. Jenn is the former president of the Mississippi Bar, co-director of educational content with me at Access Legal, and a brilliant generational attorney. She's also a huge proponent and advocate for collaborative law, which is what we're going to be talking about today. Jenn, thanks for being on the show.
Thanks so much for having me, James. Looking forward to it.
So let's get into the obvious question. What is collaborative law?
Collaborative law is a contractual alternative dispute resolution process that is completely voluntary. So it is a way for, particularly in domestic laws, domestic cases, for people to choose to go an alternative route from the scorched earth litigation that is so prevalent in divorce work and custody work.
What are the benefits of taking this approach as opposed to litigation?
Well, the one reason that I got into collaborative law or interested in collaborative law was because of my own experience through divorce and working on visitation for my two children with their dad. And we were able to work through the process without litigation, and it turned out to be a really good thing for our children. So to me, it's all about preserving relationship as opposed to destroying relationship. Because when you go to court and litigate over such personal matters as marriage and custody of children, there's a lot of damage that can be done when you are trying to prove your case. So the collaborative process gives everyone an opportunity to come together, to be thorough and transparent in how they are presenting information to each other. They've decided we're not going to play the game of gotcha.
Right.
Okay, and so this is an opportunity for everybody to sit together at the table and to say, how can we come up with a solution that is best for our family going forward? I'm a firm believer that divorce doesn't end family, it changes family. And so we always are going to be, looking for opportunities to be together. There will be graduations, there will be weddings, there will be family funerals. There will be all of these opportunities for everyone to be together. And so why don't we do something proactive to preserve family and preserve relationship in this change in circumstances when mom and dad can no longer be married?
Right. And to your point, you don't have to get to trial to destroy the relationship. Even at a mediation, mid-litigation, both attorneys will lay out their whole case, and that usually involves bad-mouthing the other parent. So I agree with you. The second you enter into litigation, you start that destructive process. So I love this concept.
And, some interesting statistics are that over 90% of divorces that are filed will settle before trial. But as you are going through the litigation process, you are damaging the other person in order to prove your case. And then if you do have to get to trial, can you imagine your former spouse or almost soon to be former spouse on the witness stand saying all these terrible, horrible things about you in open court? I don't see how a relationship survives that. And then you're going to ask them to co-parent after this. Let's work together on making sure that Johnny and Jane get to where they're supposed to be and where they need to be. There's just no way that we can expect people to be able to co-parent after they have been through such the scorched earth process of the litigation. So with 90% of the cases settling before trial anyway, why don't we try to move that process earlier so that we avoid all of the damage to the relationship? Now, listen, collaborative law is not all kumbaya. Right. Like everybody's going to be just fine and, everybody's happy to be in the same room. It's not that at all. The reality is people are going to be emotional and people are going to have some adversarial feelings toward the other person. But if we can, at the very beginning, say, we are committed to working this out so that we have a situation we can all live with and we can maximize everyone's ability to live a good life after this. We're committed to that. So we're going to take litigation and trial off the table. We're just not even going to go there. We're going to see what kind of agreement we can come to in this collaborative process. And I'd love to be able to kind of explain a little bit how collaborative processes are different from just typical settlement discussions. So a collaborative process, again, is contractual. Everybody at the very beginning, including the attorneys for each party, will have to sign this agreement that says we are doing this to settle the matter without threat of litigation. So everybody's going to sign off on kind of the ground rules for how we're going to proceed with the process. And if at any time during the process, one party decides, well, they haven't been abiding by some agreement, a temporary agreement that we've made, and so I'm going to go to court and I'm going to file a motion to enforce this agreement that we've had, that is going to automatically end the collaborative process, because now you have brought the adversarial process to the fore. So you want to be able to have a safe space where we can all be transparent, bring all of the information that we need, all the financial information, all of the children's information, school, medical records, anything like that that would be relevant to any of the discussion. You want to bring that forward without the need for a formal discovery. Everybody's going to agree that we are just going to bring what has to be brought so that everybody has all the information so we can make a good decision about things without bringing the court into it. When we do that, over 90% of the collaborative matters will settle without any court intervention. Now, this doesn't mean that the laws that are in place are changed. Right. Okay, like in Mississippi, where I'm from, the judge will have to sign off on the final judgment of divorce, but the judge doesn't have to be involved in the agreements that lead up to a final judgment of divorce. Okay, so the court will have to be involved in that way, and that's allowed and allotted for in your agreement for collaborative law. The judge will enter the final judgment of divorce just like normal, but you want to prevent having the court involved in any of those negotiations where we're figuring out what is best for our family going forward.
And I love something you said earlier about how divorce doesn't end families, it just changes them. I always have the thought in my mind, as a fellow family law attorney, every future ex-spouse is a future co-parent. So it's, there's that dichotomy there. Now, I imagine this process doesn't work for every type of case. Is there a screening process? How do you determine if a case is ripe for this collaborative process?
Yes, actually, it is the attorney's responsibility to determine if this is an appropriate case to bring to the collaborative process. There are going to be some people who are not interested in collaborating. They've been betrayed. They're very hurt. They're emotional about things, and maybe they want a pound of flesh and they want to drag somebody through the coals, okay? So those people who are so interested in retribution should never come to the collaborative table to begin with. So the attorney, as you are interviewing your client and as you're talking with them, it's a good idea to let them know that collaborative law and collaborative processes are available to them as an option, but it is an option and it is completely and totally voluntary. No court can require somebody to go through a collaborative process. Like we have some courts that will require mediation prior to trial. Collaborative process can never be ordered or imposed on somebody. It has to be voluntarily entered into. And so if we're choosing our cases correctly, that go through the collaborative process, then that's when the 90+% success rate, comes into play, is because we've said, yes, this looks like this will be a great situation for a collaborative result or process. So yeah, it really matters.
Yeah, I imagine domestic violence, things like that, like it's just completely off the table. Right. It's not even an option.
Yeah, if there's some sort of power differential there that the attorneys are aware of, then they can say, I'm just not sure that this is going to work that way, and we're just going to have to go the traditional route.
What is the role of setting client expectations here? Because they're used to TV and movies and attorneys fighting it out in the courtroom, and we've all had clients call and say, I'm looking for a cliffhanger that's going to tear her to pieces. And for the record, my standard response was, then I am not the attorney for you, because that's not how family law works. How important is it to set those client expectations, and how do you do that?
Critically important to set their expectations and to fully educate them about what the collaborative process is. So another important part of this is this contract that we're talking about that we all enter into in the very beginning. It's going to have information in there like you would normally have in a temporary order. Nobody's going to waste assets. Nobody's going to incur any more debt in the other party's name. Those types of things you can handle in an upfront agreement among all the parties. So when you're negotiating this contract, it's a great opportunity then for the client to become involved in that process and for you to fully explain how this is going to work and how it can work and explain what will automatically end the process, like filing a motion in court. So it is incumbent upon the attorney, number one, to assess the situation to determine if it's appropriate, and then number two, to fully educate the client as to what the process entails and what's expected of them. And they can expect that this process will be quicker than a litigated process where you have to get on the court's docket. It will be less expensive because we're not going through discovery disagreements and fights and waiting the 30 days or 45 days or 60 days or however long it takes for people to respond to discovery to get information. And another thing is it's cost saving because we're going to deal with joint experts. So let's say we had to have an appraisal of a home, the marital home. Most of the time in the litigated process, both sides are going to go hire an appraiser, and the appraiser is going to come out and make an evaluation of the value of the home. And there's going to be some difference in that price usually, but they're going to be fairly close. So in this process, you are agreeing we're going to select one appraiser, and we're all going to abide by the appraiser's result. And so we only have one expert that we have to pay for instead of two. You know, the pot of money between husband and wife does not grow when a divorce comes. In fact, if anything, it shrinks. And so we want to be mindful of cost-cutting opportunities as well, and this is a great way to do that.
And when you boil it back down to the family being the most important thing, that money's then going to go back to the family. So it's an important part of litigating also is, hey, do you want to spend $10,000 to get another day a month in custody, or would you rather keep that money and go on vacation with your child the time you do have? So I love that it preserves the assets there. You had touched on it being quicker. Well, what is the timing like? Is there a deadline? Do you set a contractual deadline to say if we don't have this settled in 2 years, which I imagine is somewhat anti-collaborative because now you're putting artificial, limits on things. How's the timing of everything handled?
Well, number one, that can be a matter of contract. You can agree that, well, we're going to give this 4 or 5 joint sessions and we're going to see how it goes. Or you can leave it open-ended and just say, let's just do what we have to do to get this resolved, which is typically how I have seen that happen with these cases, is we're just going to do what has to be done to reach an agreement. Because the end goal here is very different than the end goal if you're litigating in court. The end goal for collaborative process is an agreement that we both like, that we can both live with, as opposed to the goal of litigation being, I'm going to win, I'm going to get everything that I want, and I'm going to take away from you what I don't want you to have. So it's a completely different mindset.
It's soft landing it versus winning.
Yes, exactly right. And, when you agree at the very beginning that we're going to do this in a collaborative way and we're going to settle this outside of court, it's like removing the baseball bat from behind the attorney's back when they're talking to somebody, about settlement. Oh, well, we'll give you this if you give us this, and if you don't, we're going to court. And they take the baseball bat out and, that's the leverage. This process removes that because everybody knows we're not threatening court. We're not going there. And then one of the primary provisions of this contract that is interesting and controversial is that the attorneys who are engaged in the collaborative process can only be engaged for settlement purposes. If the collaborative process fails, and there is a need to go to court, the attorneys have to withdraw. And that's the teeth in the collaborative rules that just says, we're going to be very serious about this. So there are serious consequences to pulling the plug on the collaborative process. It gives people incentive to work through these roadblocks that, of course are going to come. It's not going to be everybody agreeing to everything right at the very beginning. So it gives everyone an incentive to really work through whatever those barriers are to resolution.
You had talked about, that you can build the cost of the experts into it and you're trying to decrease costs. That being said, how is the attorney charging for this service? Is that a flat fee, retainer? How does that look?
Creativity, again. So it really depends on what the circumstances are for the parties. So if we have husband and wife who are both employed, both have their own source of income and access to money, then maybe both parties can pay for their own attorneys. If there's one spouse who is the breadwinner maybe the other spouse is stay at home and not working outside the home, then it may be that we have to come to an agreement at the very beginning as to who's going to pay attorney's fees for both parties. I think this is a really great opportunity for attorneys to get creative about how they charge their fees. So we could do flat fees. We could also do a payment plan model where we have a small amount down and then continuing payments over time so that all of the parties have an affordable way to have legal counsel present for the collaborative process. One reason that it's a shorter time frame is because you're not dealing with the court's calendar. That's one of the things that will really make these processes take a long, long time. The divorce process is trying to get on the trial calendar and then keep your trial date. So this is a way for just the parties and the attorneys to work their schedule however it works best for them. And it's usually a more compact timeline for getting things resolved this way.
The benefits are obvious and multitudinous, right? There are a ton of benefits to doing this. What are the challenges to implementing this? Why isn't this known and prevalent everywhere?
Actually, there is some sort of collaborative process recognized in about 45 states right now in the United States. It is prevalent overseas as well. So, there are several countries who recognize collaborative law and lots of attorneys who practice only collaborative law. So it is out there and it is prevalent. In my home state in Mississippi, we've known about collaborative law, but no one has really picked that up and run with it to say this is something that's really good for the people in Mississippi, and we want to make sure we bring it to the fore. So that has been done now as late as August of last year. August of 2024 is when the Mississippi Supreme Court adopted the rules. So our challenge right now is educating attorneys about the new rules and about the process, educating the public about it so that they know I'd like to go to an attorney and ask for a collaborative process as opposed to litigation. And then also, educating the attorneys that it's there and then creating a community of attorneys who will practice collaboratively. Because now there are some attorneys who just are not interested in this. They get into law, went to law school and got into the law practice because they wanted to go fight over every fork in the drawer, okay? So there are going to be some lawyers who just aren't going to be interested in it. So we need to identify a community of attorneys who are interested in practicing this way so that the public has the knowledge of who can help them get into a collaborative process for their divorce. So a lot of education about the rules and about how that applies and then who is interested in practicing that way.
Jenn, I so appreciate you being on today. This has been incredible information, very informative, and I'd love to have you back sometime.
Would love to be back sometime. That's great. Thank you for having me today.
My pleasure. Thank you for joining us today. If you found today's episode helpful and informative, please like and subscribe. And tell me whether or not they have collaborative law in your jurisdiction and whether or not you're implementing that for your practice. We'll see you in the next episode.